If there are misshapen aspects of this agreement, if the scope and focus is off, part of it does relate back to the process. But it is the substance at the end that really counts. We wish there had been an ITAC. We've recommended for years that there be an ITAC that had internet constituencies included. That hasn't happened. And again, we think that could have had some impact on how things would have evolved. But we ask ourselves, are we in fact urging foreign states to enact laws that could be bad for U.S. businesses? Are we signing up to some obligations that may be inconsistent with U.S. laws? Those are two fundamental substantive questions that we ask as we look through the various parts of the agreement. Consistency isn't our goal. Good policy is. Different legal systems overseas, different traditions of how they use executive power, how they use judicial power, are really important. And to say everybody we want everybody to have injunctive power. We want everybody to have the ability to seize and require forfeiture of assets of not necessarily people who are directly doing something wrong, but who are somehow involved in the process. These are some dangerous issues fundamentally. We do not argue there are some problems out there. Some of the numbers that have been used, I think, are absurd in terms of calculation loss. We've done some major economic studies that using very similar methodology that says, frankly, that the benefits on the limitations of copyright, for example, fair use, are in fact of tremendous economic significance. And if some of that is chilled improperly for fear of liability for really conduct that we would not consider wrong, then that's a negative impact too, to answer Emery's economic numbers. But let me go on and mention an example of design patents in China. Okay? They're using those to go after foreign companies. How much authority do we want to legitimize in that? Yesterday, there was a company that threatened to sue Apple for a very large amount of money. They claim to own the iPad trademark in China. Okay? This is not a one-way street. There's a Russian example, not so long ago, a few weeks ago, where Russian authorities used copyright infringement of Windows in order to crack down and persecute civil society and dissident groups that have been critical of the government. Well, Microsoft should be applauded here because they responded. They acted swiftly and granted broad public licenses to nonprofit organizations in various authoritarian regimes to prevent that narrow kind of misuse. But it was, again, using intellectual property claims and enforcement to accomplish other goals. That is a precedent here that I'm afraid we may open ourselves up to greatly down the road with ACTA. These are the types of countries that ultimately we say we want to join ACTA. I'm not saying some of the current signatories are at great risk for some of that, although we have seen in criminal allegations in Italy, in the internet space, we've seen some recent actions in France. But we're talking about bringing in, if this is to be effective, is to bring in a lot of countries who have much less credible regimes. But we want them to have all this power. We want them to have additional enforcement authority. We want to give a lot of power, and we're going to encourage and say the best model is to do this. Injunctions, broad civil discovery, required mandatory data preservation, asset seizure and forfeiture. These are power. In this country, we have a lot of checks and balances. We have a lot of due process. Okay? We cannot assume that these powers will be so easily exercised. And we have lumped in, I think, unfortunately, whether it was mission creep or whatever, the fact is, here we are at late stage in this agreement, and we don't know the extent to which patents are covered. Any idea how many millions of patents exist? How many billions of dollars of industry are tied to those patents? They don't know if they're interact. This is a last-minute decision as to the scope of their coverage. Copyright industry, I mean, and Emery corrected a couple of things about third-party liability and shutting down sites. And that was in here for a long time as a real threat. It got knocked out in a way. It is not prohibited. It is simply not mandated. So there's still an overhang here of issues that we are concerned about. I guess I would want to make the point that, you know, in many ways, we are concerned that it's not ripe for final outcome, that there is really, there's been improvements, and that people, and we have to say, we will praise USTR for finally, in the last number of months, really making some corrective changes in the agreement. But it's a little bit like, you know, they want, you know, big content wanted the sun, the moon, and the stars, and okay, they only got the moon and the stars. It still has vulnerabilities and exposes much of industry, I think, to a level of uncertainty and risk which we don't really think makes sense. A couple specifics. I mean, are trademarks included in the Internet chapter? If so, that would be inconsistent with U.S. law. Are patents in civil enforcement chapter? To what extent that is consistent or not in U.S. law? The injunctions issues, the privacy issues. Again, I think one of the improvements we saw was things that were previously mandatory became more permissive. But when there's language in here talking about effective enforcement and various other phraseology, which really means if countries don't do almost anything that might be asked of them to stop this, they're not acting in good faith compliance. So the mandatory things that we all said we didn't like are not all, many of them are not mandated now, but they are still encouraged, incentivized in a variety of ways. So bottom line is, we're not at this point opposing ACTA. We think we would urge some continued further negotiation in a number of areas. And if we had to do over again, which I guess we probably don't, we would probably have said, do an intellectual property enforcement agreement on trademarks, on counterfeit. Then come back and bring up everybody who cares about copyright and see if we want one there. And do one on patents, see if we want one there. We would never consider trying to pass imagine what Congress would do with an omnibus intellectual property reform bill. I mean, my God, putting all this stuff in one bill. Look at the problem we have with just patent legislation. Would be a massively difficult challenge. And not make a lot of sense because these areas are so different. I think that was perhaps one of the mistakes of not staying focused first, not saying you don't go on the other areas, but staying focused at the outset on real issue of counterfeiting, where there was a great deal of consensus.